Violence, or at least the threat of violence, is a common concern among both inmates and the staff. After all, prisons tend to be filled with people who have already demonstrated a willingness to engage in violent or other unlawful acts. The level and extent of violence will greatly vary from prison to prison and for different prisoners. Different features of the prison, such as the architectural design, inmates' freedom of movement, and group and individual dynamics, these can affect the level of prison violence. Research suggests that most prisons are not characterized by the systematic and rampant violence that's often portrayed in the media. Of course, there have been and continue to be prisons and prison systems that are plagued with high levels of violence. Coercion and the threat of violence appear to be more common than actual physical assaults. Coercion may be used as physically dominating inmates to obtain items such as food, money, personal services, sexual favors. This threat of violence, including sexual assault, is very real to prisoners. Furthermore, prisoner assaults on staff and other prisoners do occur and can result in serious injury or death. Female prisons tend to have less explicit violence, as mentioned earlier, than the male prisons, though it does exist there as well. The book describes several famous prison riots that have occurred, but they are a common occurrence, and there are many that we don't even hear of, including those that occur if you live locally. I'm sure you hear in our news media of the types of violence and riots that occur at Dannemora and have occurred at Dannemora Correctional. So what causes prison violence? Violence in prison can occur on an individual basis or on a collective basis, as in a group. Riots, such as. Types of violence can include inmates versus inmates, inmates versus staff, even staff versus inmates, but we're not going to discuss that here, and self-inflicted violence. And there is no one explanation for any of them. However, research has concluded that there are theories and there are factors that can be present that can influence violent levels. And we'll start with on an individual, talking about individual violence. A factor, history of prior violence. Before inmates were incarcerated, many were violent prone. Individuals who used it to force to get their own way. Age is a factor. Younger inmates with records of prior incarceration are most likely to engage in disruptive behavior, especially if they were not actively participating in any treatment. And sadly, juveniles sentenced as adults to adult prisons, they have a higher rate of violence. Psychological factors. Many inmates suffer from personality disorders. It is not surprising that people with extreme psychological distress may resort to violence to dominate others, or that inmates with personality disorders are violently abused by others. Prison conditions. The prison experience itself causes people to become violent. Think of the conditions in a prison. Overcrowding, it's inhumane, it's a threat of violence or sexual assault, there's depersonalization, there's a lack of sense of one's worth. The most rundown prisons have higher rates of violence. And there's no difference between a high security and a low security facility if these conditions are present. Lack of dispute resolution mechanisms. Many prisons lack effective mechanisms that enable inmate grievances against either prison officials or other inmates to be handled fairly and equitably. Most of the time, issues between inmates, they don't want to become snitches. They don't want to tell on other inmates because then that puts them as a target. And prison officials, they kind of don't particularly care too much sometimes about inmates' issues between each other. Also, basic survival. Inmates resort to violence just to survive. The lack of physical security, inadequate mechanisms for resolving complaints, and the code of silence that they have promote individual violence by inmates who might otherwise be controlled. Collective violence or rioting, for example. Inmate balance theory. It's based on the belief that collective disorders occur when prison officials go too far in asserting their authority too quickly. Sometimes the crackdowns occur when officials think inmate control is getting out of hand and that it appears that inmates have too much power, and then they react very quickly to assert their power. You cause an inmate balance. Administrative control theory is another theory. According to this theory, collective violence is caused by prison mismanagement. There's a lack of a strong security and inadequate control by the prison officials. Poor management may inhibit conflict managements and set the stage for violence. And thirdly, not mentioned in the book, I don't know why, it's very important, overcrowding. As the prison population continues to climb, it's unmatched by expanded capacity. People are put doubled and tripled up in cells. It causes prison violence or increases the potential of prison violence on a collective stage. Despite these issues, there has been a decline in homicides and suicides in prison. However, coercion and physical threats and physical assaults still remain. Let's move on to rights, prisoner rights. In May, I'm going to start with a story. In May 1995, Limestone prison inmate Larry Hope was handcuffed to a hitching post after arguing with another inmate while working on a chain gang near an interstate highway in Alabama. We're talking about an Alabama prison. Hope was released 2 hours later after a supervising officer determined that Hope had not instigated the altercation. During the 2 hours that he was coupled to the post, Hope was periodically offered drinking water and bathroom breaks, and his responses to those offers were recorded on an activity log. Because of the height of the hitching post, however, his arm grew tired, and it was later determined that whenever he tried moving his arms to improve his circulation, the handcuffs cut into his wrists, causing pain. 1 month later, Hope was punished more severely after he had taken a nap during the morning bus ride to the chain gang's worksite. When the bus arrived, he was slow in responding to an order to exit the vehicle. A shouting match soon led to a scuffle with an officer and 4 other guards where they intervened and subdued Hope, handcuffing him and placing him in leg irons for transportation back to the prison. When he arrived at the facility, officers made him take off his shirt and again put him on the hitching post. He stood in the sun for approximately 7 hours, sustaining a sunburn. Hope was given water only once or twice during this time and was provided no bathroom breaks. At one point, an officer taunted him about his thirst. According to Hope, the guard first gave water to some dogs and then brought the water cooler closer to me, removed its lid, and kicked the cooler over, spilling the water onto the ground. This is 1995, which is really not, yes, it's a long time from now, but it's not really a long time ago. We're not talking about, the early 19th century. Eventually, Hope filed a civil suit against 3 officers, claiming that he experienced unnecessary pain and that the wanton infliction of pain constitutes cruel and unusual punishment, which is forbidden by the 8th Amendment of the Constitution. His case eventually reached the U.S. Supreme Court, and on June 27, 2002, the court found that Hope's treatment was totally without penological justification and constituted an 8th Amendment violation. The court ruled that despite the clear lack of emergency, respondents knowingly subjected Hope to a substantial risk of physical harm, unnecessary pain, unnecessary exposure to the sun, prolonged thirst and taunting, and a deprivation of bathroom breaks that created a risk of particular discomfort and humiliation. In deciding the Hope case, the court builds on almost 40 years of precedent, cases that came before it, precedent-setting decisions in the area of prison rights. It may be surprising, but before the 1960s, American courts had taken a neutral approach, commonly called the hands-off doctrine, toward the running of prisons. Judges assumed that prison administrators were sufficiently professional in the performance of their duties to balance institutional needs with humane conditions or humane operations. The hands-off doctrine rested on the belief that defendants lost most of their rights upon conviction, suffering a kind of civil death. Many states defined civil death through legislation that denied inmates the right to vote, to hold public office, and even to marry. Some states made incarceration for a felony a basis for uncontested divorce at the request of the non-criminal spouse. Aspects of the old notion of civil death are still a reality in a number of jurisdictions today. The Sentencing Project says that 3.9 million American citizens across the nation are barred from voting because of previous felony convictions. Although the concept of civil death has not entirely disappeared, the hands-off doctrine ended in 1970 when a federal court declared the entire Arkansas prison system to be unconstitutional after hearing arguments that it constituted a form of cruel and unusual punishment. The court's decision resulted from what it judged to be a pervasive overcrowding and primitive living conditions. Longtime inmates claimed that a number of other inmates had been beaten or shot to death by guards and buried over the years in unmarked graves on prison property. An investigation did unearth some skeletons in old graves, but their origin was never determined. So now the 1960s roll in, and advocacy groups become involved. They bring lawsuits. They were bringing lawsuits on behalf of inmates who claim that their civil rights have been violated. The argument went that as U.S. citizens, prison inmates could sue state officials if their civil rights were violated. For example, in such they were victims of racial or religion discrimination or subject to cruel and unusual punishment, typical arguments. The lawsuits resulted in increased inmate civil liberties, which now draws battle lines, or started drawing battle lines between the inmates and prison officials, but also created a clog in the federal court system, and because this is where they were filing their suits, because the claim is a claim of a violation of the constitutional right. So they're challenging it on federal grounds, so they have to go to federal court. And then Congress passed the Prison Litigation Act, Reform Act, was passed by Congress. Key requirements in that act set forth that the inmate must seek and move through the channels provided per the state's institution grievance procedures first, before they can go to federal court. That they must say that they suffered a physical injury and there was a violation of their constitutional rights. And this resulted in limits on, and they were also limited on the number of lawsuits that they can file, which was 3. Of course, inmates through the advocacy civil rights groups challenged that law and that act before the Supreme Court, and the Supreme Court reviewed 2 cases and issued a ruling. And the Supreme Court upheld, meaning they deemed the laws constitutional and not a violation. One was Booth versus Turner, claiming cruel and unusual punishment. The court upheld the act's requirement that state inmates must, quote, exhaust such administrative remedies as are available before filing a suit over prison conditions. And then Porter versus Nussel, which was also an Eighth Amendment challenge, the court said exhaustion requirement applies to all inmate lawsuits about prison life, whether they involve general circumstances or particular events, and whether they allege excessive force or some other wrongdoing. So let me kind of recap here. So basically what the court said was the act was fine, requiring those restrictions. They were not cutting them off to federal court. What they were saying is if you have an issue with the prison system, you have to go through the system first. There's a grievance process. You usually file a complaint. There's a hearing on a complaint. And then there's an appeal to the appeal board. And then if you don't get any redress, then you can come to the federal court and make your claim. But when you come and you make your claim, you have to have a physical injury and there has to be some violation of your constitutional right. If you don't have both of those things, you can't come to federal court. And the Supreme Court said, yeah, that's that's fine. And the other decision on the Supreme Court is, and this means any issue. If you have any issue with the prison system, you don't like how life is going there, you don't like a particular set of circumstances, or somebody used some force against you, you have to go through the grievance process first before you can come to federal court. Although this act slowed the movement, it did not stop. So let's discuss some of the most important cases and rights that came about. There are lots of them. We're going to hit the big ones of the rights that came about. Access. Access is to courts, to legal services, and materials. The prison must allow access, and they also must allow there to be assistance in drawing up or filing of the complaints. They cannot interfere or harass prisoners prison administration can't harass prisoners or their legal counsel with regards to access and legal services and materials. Funny, jailhouse lawyers, it's a real term. Some folks do have legal training, and there are attorneys in prison who are serving time for committing offenses that they may have done. There are people in prison with law degrees and such, and there are people who just have some special training that they've learned on their own. They've read books, and these folks proclaim to be jailhouse lawyers, and they help other inmates complete their paperwork, and prison officials cannot interfere with that. Then we have some First Amendment freedoms. Freedom of the press and expression. This relates to correspondence. It's typical that prisons censor incoming and outgoing mail. They claim that censorship of incoming mail is necessary to detect contraband, weapons, drugs, pornography materials. And they also claim that it's necessary to censor outgoing mail to protect public from insulting, obscene, and threatening letters, to avoid defaming the prison, and to detect any escape and riot plans. And courts have consistently held that officials can regulate the mail if a compelling interest exists, such as a showing that it threatens institutional security. This is a hard burden for them to meet, but they can. If they can regulate the mail, if they have a legitimate, compelling reason that threatens the institution's security. And I will say they do open the mail. They open in and outgoing mail to check for these things. They don't throw it away, and they don't retain it, but they do go through it and look before the inmate gets it. The only thing they cannot touch is counsel. Mail from attorneys and mail going to attorneys, and those are addressed in separate correspondence. And attorneys have to be on the register or the list, so they know that it's a legitimate attorney. So they can, and they do regulate in some areas. What they can't do is withhold it, keep it for unnecessary purposes. But with drug trafficking, it's a very big deal in the prison system. Freedom of religion. This is a fundamental right. Courts have ruled that inmates have the right to assemble and pray in the religion of their choice, but that symbols and practices that interfere with institutional security can be restricted. Also, institutions are not required to carry out impossible or cumbersome religious needs or grant special privileges. Like a big one is food choices. They can't do that for specific groups, dietary restrictions. It looks as though they're favoring one group over another, so they don't have to do that. In Holt v. Hobbs, the court ruled in favor of the inmate's right to grow a half-inch beard per his Muslim faith. The facility was telling him he could not, but the court ruled in his favor that said that he could, since the government was not able to show a compelling government interest or provide support for its argument that the beard was dangerous. Their claim was that an inmate could hide contraband in it. We're talking about a half-inch beard. They couldn't overcome that, and a lot of the times they just say things in the security of the institution without having any sort of basis for that. And then they leave it up to the inmate to have to go to court to challenge it. Some do, some don't. Medical rights. In early prisons, inmates' rights to medical treatment was limited to only exceptional circumstances. These cases that were allowed access to the courts, they usually represented a situation of total denial of medical care, but that has changed. To gain their medical rights, prisoners have resorted to class action suits. These are suits brought on behalf of a group of individuals affected by the same instance. And the most significant case was Newman versus Alabama. The entire Alabama prison system's medical facilities were declared inadequate. The Supreme Court cited the following factors as contributing to inadequate care: insufficient physician and nurse resources, reliance on untrained inmates for paramedical work, intentional failure in treating the sick and injured, and failure to conform to proper medical standards. The Newman case was forced correction departments to upgrade prison medical facilities. It was not, and that was in 1972. It was not until 1976 in Estelle versus Gamble that the Supreme Court clearly mandated an inmate's right to have medical care. Gamble had hurt his back in a Texas prison and filed suit because he contested the type of treatment he had received and questioned the lack of interest that prison guards had shown in his case. The Supreme Court said deliberate indifference to serious medical needs of prisoners constitutes the unnecessary and wanton infliction of pain prescribed by the Eighth Amendment. So Gamble was allowed to collect monetary damages for his injuries. In the Pennsylvania Department of Corrections versus Yetzke, Yetzke was sentenced to 18 to 30 months in a Pennsylvania prison. The sentencing court recommended that he be placed in a motivational boot camp for first-time offenders. Successful completion of the boot camp would have made him eligible for parole in 6 months. However, prison officials refused his admission to the program because of his medical history of hypertension. Yetzke then filed a suit alleging that his exclusion violated the Americans with Disabilities Act of 1990. In a unanimous opinion written by the Supreme Court, Antonin Scalia, who was very conservative, he actually agreed with the lower court as it held that no public entity may discriminate against qualified disabled individuals due to their disability. The significance of this case is that the ADA also applies to state prisoners. So today, inmates are guaranteed medical treatment when there is a serious medical need to avoid the unnecessary and wanton infliction of pain. This has been defined as 1, whether a reasonable doctor or patient would perceive the medical need in question as important and worthy of comment or treatment. 2, whether the medical condition significantly affects daily activities. 3, the existence of chronic and substantial pain. Additionally, courts may find a serious medical need if a condition, quote, has been diagnosed by a physician as mandating treatment or is so obvious that a layperson would easily recognize the necessity of a doctor's attention, end quote. So medical rights. They have a right to medical treatment in the broadest of sense, just as you and I are. Cruel and unusual punishment. The concept of cruel and unusual punishment is founded in the Eighth Amendment of the U.S. Constitution. The term itself has been specifically defined by the Supreme Court, but the court has held that treatment constitutes cruel and unusual. I should say it hasn't been defined, but the court has held that treatment constitutes cruel and unusual punishment when it does the following. And there's a list. The list is in the book. I'm just going to buzz through them real quick. Degrades the dignity of human beings, is more severe, disproportional than the offense for which it has been given, such as getting the death penalty for stealing. That would be disproportional. It shocks the general conscience and is fundamentally unfair, is deliberately indifferent to a person's safety and well-being, punishes people because of their status, such as race, religion, and mental state, is the flagrant disregard of due process of law, such as punishment that is capriciously applied. State and federal courts have placed strict limits on disciplinary methods that may be considered inhumane. Corporal punishment ended after the practice was condemned in a case called Jackson versus Bishop. Although the solitary confinement of disruptive inmates continues, its prolonged use under barbaric conditions has been held to be a violation of the Eighth Amendment. Courts have found that inmates placed in solitary have the right to adequate personal hygiene, exercise, mattresses, ventilation, and rules specifying how they can earn their release. I led with the case of Hope versus Peltzer. Just considering those facts, that was obviously cruel and unusual punishment. The U.S. Supreme Court ruled that Hope's allegations established an Eighth Amendment violation. It ruled that among the unnecessary and wanton inflictions of pain constituting cruel and unusual punishment forbidden by the amendment are those that are totally without penological justification. This determination is made on the context of prison conditions by ascertaining whether an official acted with deliberate indifference to the inmate's health or safety, a state of mind that can be inferred from the fact that the risk of harm is obvious. The court reasoned that any safety concerns had long since ended by the time Hope was handcuffed to the hitching post because he had already been subdued, handcuffed, placed in leg irons, and transported back to the prison. So the Hope case shows that correctional officials can be sued if their behavior violates an inmate's constitutional rights, and that they or any reasonable person should have surmised that the behavior was in violation of accepted practices. So cruel and unusual punishment. Overall prison conditions, prisoners have long had the right to the minimal conditions necessary for human survival, such as food, clothing, shelter, medical care to sustain human life. A number of attempts have been made to articulate reasonable standards of prison care and to make sure they are carried out. Courts have held that although people are sent to prison for punishment, does not mean that prison should be a punishing experience. In the 1994 case of Framer versus Brennan, the court ruled that prison officials are legally liable if, knowing that an inmate faces a serious risk of harm, they disregard that risk by failing to take measures to avoid or reduce it. Furthermore, prison officials should be able to infer the risk from the evidence at hand. They need not be warned or told. So if they're aware of it and they don't do anything about it, they can be held liable. There's a case that's currently pending, Dockery versus Elps. It's been pending since 2013 with regards to a Mississippi facility, which is a actual for-profit prison that's been described as hyper-violent, grotesquely filthy, and dangerous. And it operates in a perpetual state of crisis. And there is a grave risk of death or loss in limbs, some of the allegations, but there has yet to be a decision. In 2018, the court was waiting for more expert testimony. But as of today, they have not issued any sort of decision on that. And racial segregation. On August 8th, 2009, a riot in a California prison in Chino, I think that's how you pronounce it, Chino, left hundreds injured, buildings burned, and property destroyed. The disturbance sparked by racial tension between Latino and Black inmates and later sparked a great deal of controversy over the issue of racial segregation in prison. Should prisons be segregated to prevent violence among gangs like the Aryan Brotherhood and the Mexican Mafia and the Black Guerrilla Family? or should prisons be integrated like other institutions, because any form of segregation is inherently unconstitutional. The Alabama case of Washington versus Lee from 1966 was the first judicial intervention on the desegregation of prisons. The federal court held that this court can conceive of no consideration of prison security or discipline which will sustain the constitutionality of state statutes that on their face require complete and permanent segregation of all of the races in all Alabama penal facilities. So this was an Alabama facility taken up to the court. The state was therefore ordered to provide for the total desegregation of all prisoners within 1 year. And then that was done. In 2005, so from 1966 to 2005, the case of Johnson versus California, the Supreme Court reaffirmed the Lee decision when it ruled that racial segregation of prison inmates in their cells or anywhere on prison grounds is an inappropriate form of racial classification. It left it open for lower courts to decide using a standard of very strict scrutiny, like they really have to look at that law, when segregation is inappropriate and unconstitutional. Johnson focused on the policy of segregating inmates upon their arrival at prison. The court ruled that if racial segregation was allowed for incoming inmates, it would also be justified in the dining halls, the yards, and general housing areas. Segregation would only be allowed if a prison administrator could prove that there was a compelling interest in public or in prison safety. The court recognized that prisons are dangerous places, and the special circumstances they present may justify racial classifications in some contexts, but these are only in the most extreme circumstances. So it remains to be seen, in light of the Chino riots, whether the resolve of racial integration in prisons will be dampened, and that the courts, even when using a very strict scrutiny standard to pick apart that law, will find that integration in many instances is just too dangerous. So anyhow, that covers our prisoners' rights. One more topic: release from prison and parole.